Prisoners sentenced to death for terror cases. Now, if you look at, and one of the major concerns, and I think the lack of sort of civil society mobilization in India around the death penalty has been largely because India does not see a large number of executions in that sense. In the last 15 years, we've seen about 3 executions, and therefore the concern, there's a sort of perception that it's not a serious issue. But if you understand the seriousness of it, only if only in terms of, if I may put 2 aspects before you. One is for every 100 death sentences that are given out by the lowest courts, and as they go through the various processes, only about 4 to 5% are confirmed by the Supreme Court. And now if you were to view this statistic in conjunction with the fact that as to how much time death row prisoners spend in jail, the real problem is not the execution part of it, but it is about prisoners spending large number of years in prison on death row. And that is to ask, and I think it is sort of, there's very little work in India to suggest why does that make a difference. It's that there are prisoners in other categories that as well spend long number of years, but what is it about death row prisoners in India that makes it necessary to view the kind of years that they spend, and in that sense the court is unable to confirm those death sentences, that makes this time on death row so problematic. And I think it largely relates to the treatment that death row prisoners receive in Indian prisons, and the discriminatory treatment that death sentence prisoners receive in Indian jails. And if you were to look at sort of duration on, if you were to calculate a median, a national median on all of how much time has a death row prisoner whose mercy petition has been denied by the president, so that's like the last stage, and you'll see that the average is about 200 months. That's about almost 17 years, and the national median on mercy pendency, right, on where cases are, where the mercy petition is pending, is about 144 months. That's 12 years. And curiously, and of course within these cases, and I'm giving you the median, but if one were to really discuss the highest number of years and the really gross cases of injustice that happen in these categories, and I'll sort of give you the example of a case from Bihar, which has about 53 death row prisoners, 4 of them whose death sentence has been confirmed by the Supreme Court and who have already spent about 22 years on death row. And their mercy petition basically is neither acknowledged by the government of Bihar and neither is acknowledged by the Ministry of Home Affairs. Both the union government and the state government say that they don't have the mercy petition, whereas the prison records clearly show that the mercy petition was sent. So basically here you have a situation where they've spent 22 years on death row and nobody knows where their mercy petition is. And this case is also interesting, I'll come back to it. There's also the problem of juveniles being sentenced to death, and the sort of the most egregious case is of Narayan Chetanram Chaudhary, whose death sentence has been confirmed by the Supreme Court. The Supreme Court has once already refused to hear the age question on whether he was a juvenile, despite having documents showing that he was only about 13 years old at the time of the incident, and he's already spent 20 years in jail. So there's that, and recently there was a case of Sonu Sardar, who, up until the time that the president's mercy was rejected, all court records showed his age as being about 23 to 24 years old, and he was sentenced to death on that basis. Up until the time our researchers met him in Raipur prison and met his family, only to figure out that his actual age at the time of the crime was 18 years 2 months. We brought it to the notice of the court in its review jurisdiction. This is after the president had rejected mercy and the president had not considered this factor. Do not use legal aid lawyers. So this whole narrative that it is the legal aid system it's a broken legal aid system that gets to that leads to death penalty is not. We don't find it to be true. But what is true is that due to this intense fear of the legal aid system and this belief that the legal aid lawyers will necessarily ensure that you get the death penalty because they believe them to be so incompetent. Very poor families hire private lawyers by paying them very, very little money, and because of that, the money paid is so little. The kind of attention that is given to that case by the lawyers also corresponding to that, and we see that the level of lawyering, irrespective of whether it's legal aid or private lawyering, in these death sentence cases is quite abysmal, and that's something. And I think particularly there's focus and there's for death penalty scholarship in India to move away from this obsession with only looking at the Supreme Court, because I think the crisis is very much, if you read the trial court judgments, which are anyway very difficult to access, if you read those trial court judgments, you will see how the doctrine of precedent in terms of these cases that the Supreme Court lays down is hardly ever applied, and there is no real sentencing practice that the lower courts have developed. The lawyers are unaware of it, and I think there's a real crisis there, and there's a need to move away from, and I think it's true of all scholarship, public law scholarship in India, that the focus is so much only on the Supreme Court, and I think the trouble in death sentence cases is very much at the trial court stage. Treatment in prison, and hopefully I can address that in the question answer session. Battles in the Supreme Court, I think it's unconscionable for the court not to admit death sentence appeals, given that it uses its SLP jurisdiction to admit all sorts of cases, from like the ridiculous to completely irrelevant. I think for courts, and most recently in January, the Chief Justice did not admit a death penalty appeal. It has happened about, I would say about 10 times in the last 8 years. And I think that's extremely problematic, and I think we're hoping to bring a challenge to the court on that front, that the court must hear death sentence appeals. Other thing is, I want to flag very quickly, is the Shuttle and Chauhan judgment. It's a very, in terms of human rights law and in terms of comparative human rights law, it's quite radical in the fact that it says that when there's a delay in your mercy petition, when there's delay in deciding your mercy petition, the court will automatically assume that it has led to suffering and torture and cruel and inhuman degrading treatment. There is no obligation on the individual prisoner to show that that prisoner individually suffered due to this long delay. The court says legally there's an assumption that if you've spent 8 years waiting for the president to decide your mercy petition, that automatically means that there is a suffering, and I think that's going to come up for challenge, and I think we better have an answer for it, which I think we do not. And I think that sort of theorizing hasn't happened around why is death so different. And I think this is something there's a challenge we face in the report, that much of what we write is true for all categories of prisoners, or would be largely true for many other categories of prisoners. But I think there's a need to understand what is it about spending time on death row in a jail in India that makes that experience so very different from other categories of prisoners. And I'll stop with that.
Thanks, Anup, also for sticking to time. I suspect there'll be questions and you'll have time to elaborate on some of these things. So over to President Wilson.
Thank you very much, Aaron, and thank you, Anup, also. I do want to just thank everyone for the organisation of this conference and express the sense of privilege I've had in being here and being with you all. So thank you once again. For those of you not from Australia, let me tell you a story about 3 Australian men, Andrew Chan, Myron Sukumaran and Van Nguyen. All through three of whom were convicted for drug trafficking as mules and certainly not as kingpins, although perhaps with different levels of responsibility. All three sentenced to death in Southeast Asia, and in the case of Van Nguyen, executed in Singapore in December 2005. In each of these three cases, we have media reports of men who have evidenced remorse and contrition, and the cases of Chauhan and Sukumaran, men who have set up drug support programs in Karakabang prison, Chauhan completing a theology degree, and Sukumaran establishing an aid-funded art program. I mention these stories to raise the age-old question of when should justice system show mercy to those sentenced to death, and who should hold that power. Now, while these particular stories concern foreigners to the jurisdiction that convicted them, I'm not seeking to focus on that aspect of those stories today, but to just problematise the treatment of those incarcerated on death row facing the death penalty. What I want to do is offer an outline of the emerging phenomenon of the suspended death sentence, something that Anoop and I have talked a little about informally, and to note that it is practiced in China and in Indonesia it is debated. I note also that in the jurisdiction with which I'm most familiar, that as of about 2 months ago, it's also been debated in Vietnam, but I think we'll focus on the Indonesian debate, which is a little bit more advanced and certainly a great deal more public. And I want to reflect on what this offers, if anything, to abolitionists. I'm not going to indulge the comparative debate here about whether it's apposite to look to China or Indonesia. There's absolutely no argument about convergence here. There is an argument about what we might learn from the experience in the case of China and the debate in the case of Indonesia in the context of a region that is grappling with death penalty issues. I note that the work in part comes out of an ARC grant that I hold with my colleague Tim Lindsay. At its most basic, the suspended death sentence is meted out by courts, involves sentencing a convicted person to death, and then suspending that penalty for a period of time with the possibility of the death sentence being commuted to a jail term. As we will see, the periods discussed in different jurisdictions, included in effect in India, for the operation of a suspension of a death sentence vary greatly, as do the considerations about when it is to be used and the nature of the commuted sentence. I looked at Arnold then about the situation in India because I think there possibly is an argument that when a person spends a protracted time on death row but might come to expect clemency, you are in effect looking at a scenario that might be characterised as a suspended death penalty, and that is the case, for example, in Thailand, where 91 to 92% of people ultimately receive the clemency of the king, although I note ordinarily after a period of 20 years on death row. Now, fundamental questions arise for abolitionists regarding the debate of a suspended death penalty. Is it possible to be an abolitionist and debate the suspended death penalty? Does the debate of the suspended death penalty risk abandonment of the death penalty? In effect, do we risk the characterisation of the ordinary trajectory, that is, that we should be all working for abolition? Is there a meaningful test for assessing whether someone has met the threshold to have the suspended death penalty commuted? Could such a test ever be objective or consistently applied? To what sentence should it be commuted? Who should make that decision? Is such a system of suspended death penalties desirable, given the allegations of corruption in the criminal justice systems of many retentionist states? And is the suspended death penalty a form of torture or cruel and inhumane treatment? I will assume for the purposes of this paper that it is. If we assume that it is it worse than the death penalty being implemented? In short, is the debate about the suspended death penalty ultimately regressive? I'll leave you to think about that. Now, let's look very briefly to China and then even more briefly to Indonesia. China currently practices, as I said to you at the outset, the suspended death penalty, pronounced Shi, and if I've got that wrong, please see Sarah afterwards. Article 48(1) of the 1997 criminal law provides that the death penalty shall be applied in extremely serious cases if the immediate execution of a criminal punishable by death is not deemed necessary. A 2-year suspension of execution may be pronounced simultaneously with the imposition of the death sentence. I'll try and keep the discussion of Chinese criminal law brief. Extremely serious is not defined, leaving judicial discretion heavily dependent on party-state policy for sentencing, give or take the guidance in the criminal law about the mitigation of sentence. The Chauhan 1 has existed since the 1950s but received very little attention in China during the 80s and 90s, where there was the strike hard, heavy-handed criminal justice policies. Earnest reform in China is generally characterised by scholars in relation to the death penalty to have commenced in 1999 after the newly appointed Supreme People's Court President Chauhan took the helm. In January 2007, the SPC in China, so the Supreme People's Court in China, regained its exclusive authority from the provincial courts to review and approve death sentences. And by the end of 2007, the number of Chauhan decisions overtook immediate execution decisions for the first time in Chinese history. I really note a debt at this stage to Sutra Vasquez's work on death penalty in China. He was a pioneering scholar in this area. Nonetheless, it wasn't until July 2010 that the Supreme People's Court, together with several other agencies, issued 2 sets of provisions to assist with the guidance in determining when the suspended death penalty might be applied, issued in large part to assist local courts in their sentencing practice. And they set out 6 circumstances to be taken into account, including whether the family assisted with capture, whether the convict demonstrated remorse, whether compensation to or a pardon had been received from the victim's family. Research reveals that 99% of suspended death penalty cases have had sentences commuted to life imprisonment since these 2007 reforms. And other research suggests that more than half of death penalty cases have been handled by way of a suspended death penalty. Now, I caveat those conclusions a little, as the scholars who have made them have also caveated them, because stats on the death penalty are, of course, a state secret in China. Now let me move to the debates in the Indonesian context, having mentioned in passing that it's also on the policy debate agenda in Vietnam. In 2007, the Indonesian Constitutional Court, introduced in 2001, in upholding the constitutionality of the death penalty for drug offences, discussed a proposed provision of the draft criminal law of Indonesia which would allow for a suspended death penalty. This decision made several recommendations arising out of expert testimony supplied in the course of the hearing of that decision. So this is the Indonesian Constitutional Court commenting on proposed reforms rather than issuing any binding decision in this respect. It noted that capital punishment should no longer be a principal punishment, but rather a special and alternative punishment, and further suggested that capital punishment should be imposed with a probation period of 10 years. If the convicts indicate good behaviour, it may be changed into life imprisonment. I note that in the context of the expert testimony submitted to the Constitutional Court, that a member of the Indonesian Criminal Code revision team suggested that the courts might also, or those determining the commutation, might also have regard to how society viewed the particular offence, a particularly worrying recommendation in my view, but one which the court sought not to reiterate. So, where does it leave us with these insights? One in terms of practice, ironically coming from a very particular jurisdiction, and another in terms of its debates. I guess the first question is what indicia ought to inform the exercise of any discretion to commute a death sentence to a term of imprisonment. What the look around the region shows as having been suggested as criteria, or at least considerations, are compensation, remorse and rehabilitation, leaving aside the social reaction to the offences that was mooted by the experts in the Indonesian constitutional case. In terms of compensation, it is problematic in as much as it is clearly inequitable to expect all defendants to be able to compensate their victims, or to be able to compensate them either at the same level or effectively at all. It's also has, in the case of China, there have been allegations and concerns raised about cash for clemency. One of the aspects about a compensatory mechanism is that becomes vulnerable to who is charged with mediating or making efficacious, if you like, a compensatory mechanism. Noted. Remorse, but I'll pass it back. Both jurisdictions have looked to remorse, which is not itself unproblematic. I mean, it's problematic in philosophical terms. Does the repentant person have a better character than the unrepentant person? I'll leave you to think about it because I'm starting to gallop now. Remorse blunts the edge of retribution, arguably. It engenders forgiveness, and maybe it is a basis for the mitigation of punishment. But again, we need to think about that. How can one assess remorse? How can one assess genuine remorse? And in particular, how is that assessed while a person is incarcerated and on death row? Further, are there cogent reasons for asking for remorse in the first place? Though evidence of remorse may be relevant to parole boards, we usually think that if a prisoner has served their full sentence, we have no business asking of their remorsefulness on release. After all, the issue of remorse has been taken into account when sentencing. Again, we need to think about this. Rehabilitation, similarly, what tests, thresholds or benchmarks might be used in this context. There are, of course, other issues beside what might be the criteria for a commutation. Obviously, there are concerns about the objectivity or propensity for bias or prejudice in the minds of those making these decisions. I just note in passing that the propensity for bias and prejudice also exists at every point in the criminal justice program, but there is good scholarship suggesting that it is particularly vulnerable to bias and prejudice when taking into account a range of value judgments about issues like remorse. If we accept the prolonged threat of imminent death constitutes a form of torture, which, as I've said, I do, and I'm not alone in that, what impact then the suspended death penalty? Is it possible to reduce the incertitude and anguish of prisoners? And that probably largely turns on what test is determined to apply. Further, does a short duration of the suspension reduce the impact and incidence of torture? And we are not in a position to answer these questions here and now. So, if a suspended death penalty is to be judicially imposed, it has to differ qualitatively, arguably, from the clemency process. So I suggest these obviously as two very different strategies. Further, if criteria cannot be devised to avoid the indeterminacy of remorse and inherently speculative nature of prospects for rehabilitation, then pursuing the suspended death sentencing will at the very least demand difficult judgments. But I do note that those difficult judgments are equally applicable when a court determines to sentence someone to death in the first instance. Remaining questions include, could such a test ever be objective, consistently applied? And I think the answer to that will vary considerably between jurisdictions. So, is the introduction of suspended death penalty capable of being progressive? I really turn that question over to you. But perhaps the suspended death penalty has more potential, at least from an abolitionist's optic, If it is the default position, everyone gets a suspended death penalty in the first instance, still with a view to removing the death penalty, obviously, from the statute books. The moral dilemma for an abolitionist is that the default position is normally no taking of life. And I think many commentators who occupy that position shy from debating a default position of a suspended death penalty, accompanied by a ratcheting up, we would hope, of the requirements for the death penalty. I suggest that the relative silence on this issue in the debate rests on the fact that abolitionists find it abhorrent. But in that, are we missing a chance to mitigate the incidence of the death penalty in retentionist states? And certainly the argument coming out of socialist China is that we are. Thank you very much.